I have a case now. What our panelists are Attorney Dwazendra Smith and Judge Nicole Sheppard. Attorney Dwazendra Smith will present first, followed by Judge Nicole Sheppard, and I will turn it over to you, ladies.
Thank you so much. Thank you for having us on this afternoon. I'm really excited, and Attorney Smith, good to see you.
You too. I'm excited as well to be on a panel with a judge. Very excited. So, like Ms. Dickerson said, I am Attorney Dwazendra Smith. I am currently a partner at Duran and Cawthorn Law Firm. Been practicing, this is my 11th year. Throughout the course of my practice, I've practiced basically everything: state court, federal court, criminal law, family law, personal injury. And I'm a rules person, and I'm well versed in these rules, and it is my objective today to help y'all also to be well versed in these rules as well. So I was given a couple different topics to talk to y'all specifically about from Ms. Dickerson, so we'll just dive right into that. So the first thing that I would like to talk about is preparing pleadings. The first thing that you need to do before you prepare any pleadings is to make sure that you have read the rules to make sure that you're preparing them right. And what I'll do on each of my topics, I'll take you through state court and then also through federal court. So as far as the state court is concerned, all of the rules are found on the Louisiana Supreme Court website. They have what's called the rules for proceedings in district courts, family courts, juvenile. And because I am on my phone, what I will do is I'll turn this around because I can't share my screen from my phone. It's gonna be too little, so I'll just do it on the computer so that y'all can see exactly what I'm talking about. Okay. Well, let's do it like this. Okay, so this is the Supreme Court website. And this is exactly where you're going to find all of the civil, and they also have criminal on here as well, the rules that you need to know for district courts. And also everything that I'm talking about today, I have an outline of this and I'll give it to Ms. Dickerson and she can send it to y'all so y'all can have this material if y'all are interested in it. So y'all can know exactly where to find this stuff at. So just to take y'all through this, because I've seen in my practice attorneys that have been practicing as long as me, some of them don't even know the rules. So I think it's very important that you know the rules and make sure that you're well versed in the rules. So Title I, rules for proceedings in district courts, family courts, and juvenile courts. Title II is rules for civil proceedings in district courts. Title III is rules for criminal proceedings in district courts. Title IV, rules for family law proceedings in district courts, in the family court for the parish of East Baton Rouge, and proceedings in juvenile and district courts pursuant to Title 4D of the Social Security Act. Title V is about juveniles. Title VI, which I'm sure y'all didn't know, they have rules for litigation filed by inmates. Very interesting. And then they have the district court rules is in PDF format. So you can click on that, save that right to your computer. And then also they have appendices to all of the rules. So this is for all the different parishes. And I'll just click on these so y'all can see exactly what I'm talking about. I see something at the bottom about questions. I do a lot of these Zooms, so I personally don't care if y'all come off of mute and ask a question. I'm not sure how Ms. Dickerson prefers the format to be if she wants you to save it to the end, but I don't care if you come off of mute and ask any questions that you have. All right. So Title I, all these rules on just about anything that you need to know. And this is mostly a family court, juvenile court. So if you practice family law, do juvenile, this is where you need to be. Okay, she said we have 10 minutes at the end. Okay, all right, so I'll just proceed. Now this right here, if you practice civil law, this is where you need to live at, rules for civil proceedings in district court. In addition to the Louisiana, what is it? The Code of Civil Procedure and all those other rules that we have. So this right here is going to tell you everything that you need to know about the procedure for civil court, discovery, alternative dispute resolution. They tell you about the allotment of cases. 9.5, I know a lot of y'all have heard the judges say, yeah, add a 9.5 certificate. What does that mean though? This is exactly what the judge is talking about. And there's specific language that you're supposed to have in your 9.5 certificate, and it's right here in the rule for you. Form of pleadings, and I'll talk about that a little bit later. There's a specific form that your pleadings are supposed to be in for civil state court. Signing of pleadings, this tells you about if you're filing an exception or a motion, exactly what's supposed to be in it. You're supposed to set it for a hearing. If somebody's opposing it, it's telling you what you're supposed to do. They tell you when you're supposed to serve that on the other party, all of that. All that's in these rules. Okay, and then we have criminal proceedings. So if you practice criminal law, there's rules on that as well. And then of course, juvenile, and then litigation filed by inmates. Let's look at this because it sounds very interesting. Okay, so this is compliance with administrative procedures and actions filed by offenders, prisoners. So before they file anything, there's certain administrative procedures that they have to follow. I have to tell some of my federal criminal law clients this a lot, that there's procedures that they have to exhaust before I'm able to do anything as their attorney. Venue statutes, there's a lot in there. So y'all just at your leisure, go back and look at that. And then there's the appendices. Let's see. There's one, I'm trying to find it, where it has all of the courts by the parishes. Okay, this is the one. So the first one. So this is every single judicial district from the 1st to the 40th. These are the appendices. So you click on this and it tells you for whatever judicial district that you're in, these are their appendices. And on certain issues, this is what they want you to do. And I know specifically in the 15th, they are very strict about you following this and following the local rules. So just make sure that you're doing all of this before you file anything, or you'll get a nice little love letter a lot of times from either the clerk's office or from the judge's office. All right, so that's where you find your rules for district court, family court, civil proceedings, criminal proceedings, all of that. All right, so that's on the state side. So now I would like to talk about the federal side. Where do we find the rules for federal court? And first and foremost, I know y'all should be aware of it by now, you have to actually be admitted into federal court. There is a nice little CLE that I took. It's called the Malcolm, I want to say M. Monroe CLE. At the time, it was, I believe, in New Orleans. So you basically go for a full day and you get admitted into the Eastern District, Middle District, Western District, and also the U.S. Fifth Circuit. So look into that. And I actually Googled that a couple of days ago. They don't have the dates on it yet for this year, but just check on that. Trying to see if I put that in my materials for y'all. Let me just Google that right quick for y'all. Yes. So it's called the Malcolm M. Monroe Federal Practice Seminar CLE. And I know on one of these websites, they said they didn't have the date for 2020 yet, but that's how you get barred or admitted in all the different federal courts. Because if you're not admitted in federal court, you'll get a notice back from the clerk's office letting you know that you're not admitted and you can't practice in federal court. So that's very important. All right. So the federal rules. I am on the uscourts.gov website, and this has all of the federal rules of civil procedure on it. Let's see, they have the appellate rules, they have the federal rules of bankruptcy procedure, everything. This is what I was just on, and this is 140 pages that shows all of the civil procedure rules and everything that you need to do. Also, when you're on these websites, I do this a lot. I go to the corner and click on find, and you can search whatever you're looking for, and it'll pull it right up in the document. Tells you the different stuff, service, filing of pleadings, whatever you're searching for. I use that a lot. All right, so that is the federal civil rules of civil procedure as a whole. Now, like I just talked about, there are 3 different districts, if you will. It's the Eastern District, the Western District, and the Middle District. So they all have their own separate websites as well. This is the website for the Western District. Now, just like state court, all the different federal courts, they have their local rules as well. They have all their stuff in PDF. I would suggest that you go on all these websites and just save this information so that when you have something in these different locations, you'll have your rules with you. Another thing in federal court, the judges, they usually have different things that they would like done in their chambers. There's standing orders. Sometimes judges have standing orders for certain cases. I know a lot in criminal law, they'll have different standing orders. Okay. And then of course you can search the different chambers, the different judges that you're looking for. And it gives you all their information. They tell you who their courtroom deputy is. They have forms, if they have certain forms for their courts. So this is what Judge Hicks would like for y'all to use. This is an order setting a scheduling conference. It's in Word format, so you can just fill it in. All right, so that's the Western District. This is the Middle District. Same thing. Middle District has a set of local rules as well. It's in PDF, you can save that. They even have links to the other courts on here, links to Eastern District, links to the Western District, to their local rules. And let you know there's 3 different sets of local rules. So make sure that you know where you are and that you're looking at the correct local rules. Because the good thing and the bad thing about federal court is that they send you an email for everything. And, you know, it's not like state court where you just go file something and basically the other attorney files an objection to it. The clerk's office will send something back quick telling you this is not in compliance. You need to make sure that you file this properly. That's why a lot of people don't like federal court, because it's a lot of rules. I love it on the other hand. All right, here's the Eastern District, same thing. Local rules, ooh, disciplinary rules. Rules for lawyer disciplinary enforcement. This is what we don't want. That's something that would be very interesting for y'all to read, because you don't want to end up like we used to say in law school, in the back of the bar journal. So just make sure you're doing everything right and in compliance with these rules. All right, so that is where you find the rules for all of that. All right, I'll turn the camera back around. All right, so now that y'all know where to find the rules at, and again, that's not all the rules, because you also have the civil code, and then you have the code of civil procedure if it's civil law that you're practicing. And then you also have the code of criminal procedure if it's criminal law that you're practicing. So just make sure that you're looking at a combination of all of those different rules to make sure that you're doing everything right. So that's one way. Another way is if you know a seasoned attorney, you can call them and pick their brain. I'm sure they won't have any issues with that. People call me all the time and ask my opinion on different things or how to go about doing something. And, I have no problem with telling them, because we want to make sure that we're upholding our other attorneys and making sure that everyone is following the rules and actually holding themselves to the higher standard that everyone else holds us to. All right, so now let's talk about pleadings. So for state court pleadings, there's a couple different things that your pleadings are supposed to consist of. So this is Louisiana Code of Civil Procedure, Article 852. And if y'all don't know by now, y'all will know by the end of this. I'm a rules person. So just about everything that I explained to y'all, I'm going to point to the rule to it so you can know I'm not making this up and that this rule really does exist and it's something that you need to follow. So 852 says that the pleadings allowed in civil actions, whether in the principal or incidental action, shall be in writing and consist of petitions, exceptions, written motions, and answers. 853 tells you the caption of the pleadings. So the top part, exactly what is supposed to be in there. Every pleading shall contain a caption setting forth the name of the court, the title, and the number of the action, and the designation of the pleading. Now, if y'all don't know what I'm talking about, y'all can ask me about that at the end. I can pull up a pleading and show it to you, because I know some people are visual. The title of the action shall state the name of the first party on each side with an appropriate indication of other parties. All right, 854, form of pleading. There's no technical form of pleadings. So in other words, there's not a set way that you have to do it. Although there are certain things that must be contained in a pleading, but it doesn't have to be done a certain way. All allegations of fact in the petition, exceptions, or answers shall be simple, concise, and direct, and shall be set forth in numbered paragraphs. So I'm sure y'all have seen pleadings before where you'll see like the 1, 2, 3, 4, 5. That's what they're talking about by the numbered paragraphs. Because when you have someone that files an answer, they're going to answer it by the paragraphs. And again, if y'all don't know what I'm talking about, just let me know at the end and I'll pull something up so I can show you exactly what I'm talking about. All right. For state court pleadings, now this is their first website that I was on under the civil district court rules. This is rule 9.6. All pleadings shall be typed or printed legibly, double-spaced, and on legal size white paper. Margins shall be 2 inches at the top and 1 inch on the sides and on the bottoms. So make sure that all of your state court pleadings are on long paper. In other words, make sure it's 2 inches at the top, 1 inch on the other sides. The reason that they do the 2 inches at the top is because the clerk's office, they punch holes in it and put it in the files, and that gives them room so that it won't be cutting off the caption and all of that. All right, for federal court pleadings are going to be the opposite. It's not on legal paper, it's going to be on short paper. And I've not found a rule that says anything about the margins, because everything in federal court is going to be filed electronically. So I don't think it really matters about the margins. If y'all are aware of a rule, let us know. Each one teach one. All right. Now, a couple things about the pleadings in federal court. I'm looking at Federal Rule of Civil Procedure, Rule 7. They tell you specifically the pleadings that you can file in federal court. Only these pleadings are allowed: a complaint, an answer to a complaint, an answer to a counterclaim designated as a counterclaim, an answer to a cross-claim, a third-party complaint, an answer to a third-party complaint, and if the court orders one, a reply to an answer. So those are the only pleadings that you're supposed to be filing in federal court. Now, of course, there are motions and other papers. We're not talking about that. So no, y'all are aware of summary judgments, exceptions, things like that. So of course you can file that as well. All right, let's talk about signing of pleadings. Both state court and federal court, there are very specific rules regarding signing of pleadings. For state court is going to be Code of Civil Procedure Article 863, which tells you specifically every pleading of a party represented by an attorney shall be signed by at least one attorney of record in his individual name, whose physical address for service or process shall be stated. A party who is not represented, so a pro se litigant, shall sign his pleadings and state his physical address for service or process. All right. And I have some other stuff, but I'm not going to read all it and bore y'all. For federal court, it's essentially the same thing. Every pleading, and this is Rule 11, every pleading, written motion, and other paper must be signed by at least one attorney of record in the attorney's name or by a party personally if the party is unrepresented. The paper must state the signer's address, email address, and telephone number. For state court, everything is filed. So this is why they talk about an email address. I've seen some attorneys put their email address on, I'm sorry, I meant federal court. I've seen some attorneys put their email addresses on state court pleadings, and that's fine. I see nothing that prevents you from doing that. But in state court, in federal court, this is why they ask about the email address, because everything's electronic. So if you're admitted in state court, you want to make sure that you stay on top of your email, because there's nothing that's going to be coming in the mail. They're going to email you when another attorney files a summary judgment, or when there's something, some type of order or something that is sent out by the court. So make sure you stay on top of that, because you don't want to miss any deadlines. All right, real briefly, state court filing of pleadings. So there's a couple different ways that you can file pleadings in state court. You can mail it in, you can file it in person. I put walk it through, but with COVID going on, they're not allowing that right now. It used to be where you could, let's say if you had a summary judgment or something and you wanted to see the dates that the court has to set it, you could take it to the clerk's office, file it, and say, hey, I'd like to walk it up to Judge Sheppard. And then you walk over to Judge's office, say, hey, Judge, I need this signed, or if it's an ex parte temporary order for custody, something like that, you walk it over to the judge. They're not doing that right now. You can also fax file it, but just know that with fax filing, there's a specific rule that tells you if the original is not received within a certain amount of time, it's as if you never filed it. What does that mean? So if I fax file something today, and today is the day that it prescribes, and it is not received within that time period, your case has just prescribed, and now you have a malpractice issue. So make sure you follow up with any fax filings. They also have electronic filing in state court now. In some of the state courts, for federal court is all electronic filing. All right, and the last thing that I'm going to talk about before I turn it over to Judge Sheppard is going to be service. So for state court service, the initial pleading is going to be served by the sheriff. There's also an option if you talk to the other party and they just want to waive service, you can get them to sign that and you can file it into the record as well. Now, anything after the initial pleading, and this is Code of Civil Procedure Article 1313, you can serve that by mail, email, fax, anything like that. So if y'all will notice on pleadings where it says certificate of service, that's what they're talking about. That is a form of service, but that's after the initial pleading. Now, if it's something that needs to be set for a hearing, that is going to have to be served by the sheriff. For federal court, I usually get a court reporter to serve those pleadings, because in federal court, there are certain papers that you have to print out for subpoenas and different things like that, and then get it served, because they don't serve like they do in state court. And I will now defer to Judge Sheppard, and I'll wait on any questions y'all have at the end. Thank you.
Thank you, Attorney Smith. Good job on the presentation. And thank you again, Director Dickerson, for having me participate with you all. So I am a class of 2005 graduate. I love SULC. My son is a 2016 graduate. I have another son who is in law school now. So I love Southern, and my law clerks are Southern grads as well. And I think it's just important for Southern to host CLEs on a regular basis for alums and whoever else wants to participate. So again, thank you, Director Dickerson, for allowing us to proceed. So I am going to talk to you all about do's and don'ts about going to court. And so what happens is, I think sometimes people have just different understandings about like what happens in court. So I just kind of want you guys to, enjoy the presentation. Can you guys see the PowerPoint? Okay, you can't see it? Okay, because I have two PowerPoints up, so I'm trying to make sure that you guys can see the one that I kind of need to operate from. So do's and don'ts of going to court. I can tell you that the first thing that I would encourage you guys to really pay attention to is when you actually file your petition. Professor Wilson was one of my professors there, and she always would talk about well-pled complaint. So I would tell you all to just kind of be paying attention to that. Make sure that the information is correct in your pleading. Make sure that you clearly state why venue is relevant, and also make sure that whatever allegations are clear. We get exceptions of vagueness filed all the time. And so just to try to avoid that whole process, I think just make sure that you have that. You're filing your documents with the clerk of court for the respective court. Make sure that you actually sign the pleadings, because sometimes we have attorneys who forget to sign pleadings. Make sure, as Attorney Smith talked about, your formatting, and so the 2 inches, they do make a difference. And even when your pleading will continue to the second page, still drop down, so that way when those documents are placed into the record, it'll fold up and it won't cut off whatever your writings are. This is a real big thing for me, courtesy copies. So after you file your petition, if you're filing any documents that will require a rule date setting, make sure that you provide a courtesy copy to the division. So my eyes are older, I have to wear reading glasses, so I don't want to read from a computer. My law clerks can. So, for my division specifically, you can email my law clerks, but for me, you have to provide a courtesy copy. So you can do that by mail, you can do it by hand delivery, but I need that hard copy. And so just kind of figure out which method your judge wants to utilize, and just try to do that. And then also the correct law. And so we research, and I tell lawyers all the time, I have 2 law clerks, but I read documents. So make sure that you are giving me great, credible information, and don't make up the law as you go. Make sure that you also shepherdize whatever law that you're using, so that way that's clear for the attorneys. And then pay your fees. So when you actually file your complaint, pay your fees. Some people have relied on the informal paupers form for litigants who may not be able to afford a fee. But make sure that you do that process a little bit earlier, because if the judge feels that based on the information provided that informal paupers is going to be denied, then you can find yourself in a position that you don't want to actually be in. So make sure that you pay your fees. Attorney Smith also mentioned fax filing. So I can tell you in COVID, so for civil district court, in the 24th JDC, not really sure what they're doing in the 19th, but for the 24th and for civil district court in Orleans Parish, you can come to court. So we had during COVID, people were still coming to court. They were still filing. We were still answering phones and processing paperwork. So for our courts, we have some judges that are actually having live hearings and matters that are actually set. Especially for our domestic docket, so our divorces, protective orders, and all of those hearings are still going on. And then for our general docket, we have people that are actually coming to court. So first, you can come to court. Our clerk's office they are set up downstairs. Our sheriff's office is set up downstairs on the first floor. So if you decided that you had to file anything for us, you can actually bring it in. We have a duty judge that is operating as well, so you can get certain things signed by the duty judge. If you need a specific date, our process is that you would go to the division. The division will give you the date, and then you can take it to the duty judge, and the duty judge to sign it. So you can actually come to our court. If you are fax filing, if you fax file it, the biggest thing that we see is that people will fax file, but then they don't send in the original. And so the code has provided a certain timeline for you guys to do that. So make sure that if you fax filing, and then count your days and make sure that you send in the original document coupled with the appropriate fees. Because if you send in the document and you don't send in the fees, it's just like you didn't file it at all. And then if you file it, fax file it, and you don't send it in, then guess what? It's just like you didn't file it. Our e-file system, so when COVID first started, we allowed people to e-file, and we reduced the fees for that. And so people were able to just actually e-file, and we get a plethora of e-files. So that's an option as well. You can submit your pleadings by mail. And like I said earlier, you can, come in person as well. Requesting service is really, really important, because we've had cases where, for whatever reasons, attorneys will say, okay, well, hold service. When you're saying that you're going to hold service, you only have that 90-day window. And if you get to the 95th day and decide that, oh, well, you know what, I needed to request service now, then if it's outside of that 90 days, then a skilled attorney will file an exception for you, and then you will have a rule day. And insufficiency of services is a real big issue. We've seen some cases completely dismissed based on that exception. So when you file your pleading, if you know that you're filing suit, for most sheriff's offices around our state, the request for service fee is usually minimum. So, like in our parish in Orleans, I think it's about $30 now. And in Jefferson Parish, I think it can't be much more than that. And I'm saying I think because I haven't practiced, obviously, so I don't know their fees exactly, but I can tell you that just requesting the service probably would save you some additional headaches, because if you don't, that exception will come through, and you might have your whole case dismissed. One thing that I would encourage you guys to also do, if you are filing your original petition, attach the interrogatories to that petition. That's going to give the attorney on the other side 30 days to actually respond. But I think it just sets a different tone to say, I'm coming to court, I'm ready to proceed, and if we got to rumble, let's rumble, but I'm ready to proceed. So I think if you guys can attach the interrogatories to your original petition, that's important. Also, you may want to calendar the case and say, okay, well, you filed on, January 2nd. You should have requested your service. So 90 days out, you have your service. Make sure that you check to see if an answer was filed, so that way you can know who the opposing counsel is on the other side. And then try to have a communication deadline schedule, saying that you're going to communicate with that attorney, I would say within at least 6 months after you actually filed. Then at that point, after you communicate with the attorney, see if you guys can move forward to some type of settlement. If it looks like a case that you won't be able to settle, use the court. Come to court, request a status conference, pick your discovery deadlines, and move the case forward. Keep in mind that case is abandoned after 3 years. Some people wait for you to not do anything on the case so that it can abandon. So just kind of pay attention to that. Also, follow the rules. Know what authority applies and pay attention. So as stated earlier by Attorney Smith, go to the Supreme Court. Go to their website and you'll see the Louisiana Rules of Court there. And I would encourage all of you all to refresh yourself on the Code of Civil Procedure and just look at the Civil Code if you're practicing in those areas. If you're practicing the criminal, do the same. Because what happens is our laws are changing. And so look at the updates. Certain legal journals will give you updates, and they'll kind of tell you, like, where to find certain things. But you got to kind of know what the law is, and you want to make sure that you are citing good law. Another thing too is make sure that you are adhering to the deadlines, because that's really important too. And you don't want to have your case dismissed or your case adversely affected because you didn't know about deadlines. And sometimes what I've just seen throughout is sometimes lawyers don't know. Sometimes lawyers forget, and sometimes they just forgot. I didn't know. I had a lawyer who was in court recently who said that he never got served. As an officer of the court, I said, well, I have to believe that you're telling me the truth. We had some information that was presented that indicated that he may have gotten served. It was a motion for summary judgment. I allowed the case to be continued to the next setting, but it was very concerning because he was saying that he never got served. And then I had one attorney who was saying, no, we definitely served him. So make sure that if you are having any kind of rules that's going to require obviously somebody to be on the other side, communicate with that person. Make sure that you get service, whether you're using 1313 or whether you're using the sheriff's office. You can use 1313 service. However, we do have a lot of attorneys who will file with the sheriff's office to file a motion to serve on the motion for summary judgments. And some of the other pleadings, just so you have that additional backup where you have the sheriff, this third party, who can say, yes, I did personally serve, I made domiciliary service on whoever the other side is. So just make sure that you're paying attention to that. When you are calling the court and communicating with court staff. So whether it's the law clerk, the minute clerk, the court reporter, I have a court crier, but I have two law clerks, and so I have one of my law clerks who acts as a crier. I can tell you that we are very hands-on active division. If you ask questions, sometimes I think it just helps. It kind of saves you time. It saves your client time and money as well. You can ask questions about how you are supposed to proceed as it relates to the division. So whatever division of the court that you're in, I would just encourage you guys to make sure that you contact the divisions and make sure that you're doing things the way that they want you to do it. I wouldn't just haphazardly just decide, okay, I'll do it this way, because it could be problematic. Like for my division, the courtesy copy is a really, really big deal. If you are the mover on the pleading and we don't have a courtesy copy, then you run the risk of being removed from the docket. Also, in this COVID climate, we are doing our hearings by Zoom. So it's beneficial if you call the court to find out how we're proceeding, so you can know, am I appearing live for a hearing or am I doing it by Zoom? And I think if you just make that simple phone call. Status conferences, we set status conferences to help people pick their discovery dates, and so we give you a form. Attorneys can decide if you need assistance from the court in helping you pick dates. We can do that for you as well. We also are real big on settlement conferences, and so again, following the pleadings, we will, if you request a status conference, we generally try to set your status conference for you within 35 days of filing. If you need a settlement conference, we generally try to set those within 60 days of filing. And we encourage people to come to court. We also mediate cases for attorneys when we're in the settlement conference mode, so we can try to see if we can bring people to closure. I would encourage you guys to make sure that when you're communicating with any court staff, that you are respectful to the court staff, because if you're rude on the phone, if you're rude in person, then that information is generally just going to be shared, and it just kind of looks bad for you as the attorney if every time you come to court you have this fire and it's everybody else's fault but your fault. If you're running behind, if it was a mistake was made, just kind of own up to it, and usually I think people will respect you more if you actually acknowledge that there was an issue and there was an error, and then we all work together to try to resolve that error and issue. But if you just kind of blame it on staff. So we actually had a court runner who we have no idea what she did with the pleading. So she brought in a pleading, and we have no idea what she did with the pleading. And it was like a whole big thing where nobody could find the pleading. So it wasn't with the clerk's office, it wasn't with the sheriff's office. The lawyers were calling, and it just became a really, really big deal. And this one person, she blamed another division and said that the division had lost the paperwork. The division was like, we never even got the paperwork. So just kind of like own up to it, and then just try to be respectful to staff. Also be respectful to the people in the clerk's office. When I was practicing, I can tell you that the people in the clerk's office, they were very effective with knowing what had to be filed and where it had to go. And they were very, very, I think, accommodating to me. And so I just think that, try to be nice and respectful to those people, because generally they do know the work, because they've been doing it for quite some time. So I would just encourage you guys to make sure that you're nice to those people as well. Make sure that you are prompt and prepared. Make sure that review your pleadings before the hearing. I can tell you that it's interesting to me sometimes when parties will come to court, and then I know more about their cases than they do. And I'm like, okay, so like, did you not like read it and prepare before you got here? On your settlement conferences, if you're dealing with a personal injury case, know how many times your client treated. If you're on the defense, know how many times the plaintiff actually treated. Be able to talk about the type of treatment that was had, talk about any imaging that occurred. If there's a dispute as to liability, be able to articulate that dispute to the judge so they can try to help you guys determine whether or not this is a case that you guys can settle, or if it's a case that you have to go to trial. If you have a settlement conference, I would encourage you guys to get authority before from your clients. So if plaintiffs didn't get the authority, or the defense didn't get the authority, then it's kind of like a waste of time, because we can't really move forward. So I would encourage you guys to do that. As it relates to rule days. And so if you have a summary judgment that is before the court, just know that don't think that you just kind of come to court and you get to argue and you're going to make this wonderful argument. And that means because you made this wonderful argument, then you're going to win based on that oral argument that you put forward. I will tell you that, and what I've learned more from the judge side versus practicing from the practicing side, is that generally when you file those pleadings, the court is going to read the pleadings that you filed, and those readings will speak for you. So I would encourage you guys to read and then prepare a great pleading. So that means that prepare, have your cases in there, make sure that your cases are relevant, and then the judge may ask you a couple of questions about the case. And sometimes that happens. Be able to answer those questions. So make sure that you're reading. Know the cases that you cited in your pleading, and know what the cases stand for. Sometimes when attorneys are placing the cases inside of their pleadings, I go and pull those cases and just make sure that it stands for what it says. I have great law clerks, but I do a lot of work, because I just feel like I have to make sure from a judge standpoint that I'm prepared. Always try to be on time. When the court is ready to begin, it's really important to start. Most courts try to respect attorneys' time, so it's always helpful if attorneys are respectful of the court's time, and then other lawyers as well. And then when you are coming to court, make sure that you have a copy of your documents and everything that you filed, so that you can reference it. If you need a continuance, notify the court timely. And let me kind of explain to you about the continuance. If you are not the mover for that particular setting, then you don't automatically get to have a continuance, because you're not the mover. So it's important to contact the mover, have a conversation with that person, and then say, okay, well, if they agree to the continuance, then you can file on the post motion to continue. If they disagree, then you may want to try to set up a status conference with the court, so that way you can explain to the court why you need to have the continuance. But just following the motion to continue just won't necessarily get you the continuance. First thing that we look for is who is the mover and the original setting. And sometimes it's interesting because we have attorneys to try to continue other people's motions, and then that's not procedurally correct. So just kind of make sure that you are prepared for that. And if you do need the continuance, just ask. We had a conference call on yesterday, actually. So we had one attorney who said that they wanted things continued because they were experiencing some health issues. Opposing counsel, and they did have a conversation. I tried to have a conversation, and the opposing counsel was just like, no, we're not agreeing to that. And then I had to decide on whether or not the continuance would be granted. So if you're in that situation, just make sure that you timely request it. So that way, if your opposing counsel is not cooperative, you can at least communicate with the judge to try to get the continuance that you need. When you go into court, sometimes courts will have sign-in sheets to kind of make sure that you either sign the docket or you complete the sign-in sheet. Also, read the sign-in sheet to make sure that you are signing in the correct space. If you need testimony to be offered, then you kind of want to get a special setting date because generally on rule dates, it's not usually testimony driven. It's usually argument driven, and that argument is being had by attorneys. I already told you guys about the courtesy copy, but I think that if you have anything set, bring your courtesy copies in so that way that individual judge can actually read it, because that's really, really important. And that's really, really important for my division and Division J. Oral argument, keep in mind that when you're making your oral argument, try to have talking points, like have a sheet in front of you and have talking points. Most courts will not allow you to stand in court and read your complete motion for summary judgment or your complete motion to eliminate or your complete exception. So try to make talking points. If there's anything that you want to hone specifically on, just know that being concise is really important, and just kind of take it as the judge and the staff, they've already read it, because most judges and staff have already read it. And so I tell people, don't regurgitate to me anything that you've already submitted in your pleadings, because I read, I highlight, and I'm prepared. So you look at the process. So whoever is the mover, whoever actually filed the pleading, will have first rights to argument, and then we'll have opposition. We'll hear from the opposing attorney, but then the mover will have a chance to rebut. And then sometimes the other person, the opposer, will say, okay, well, can I come back and say something? No, you can't. So the process is mover, and then opposer, and then mover and rebuttal. And so make sure that you're prepared for that, and you realize that it's not like a back and forth kind of setting. And so that means that when the mover makes their initial argument, when you're stating your opposition, you want to include all arguments that you thought of in that opposition. You want to get everything in, because you only have that one shot. And so you got to kind of try to get everything in. Don't be repetitive. Don't take long. And generally, if the judge tells you, okay, well, I got it, I understand, then that's kind of like a nice hint for you to kind of wrap it up. And then don't just kind of keep pushing, because if the judge tells you that they understand, then generally they do. Also, consider the court reporter when you are making your arguments, because the court reporter, they have to actually record everything that you're saying. So if you're reading, try not to speak too fast, because again, they have to record everything that you're saying. And I would encourage you guys to not interrupt the judge. Know your opponent when they are speaking, but don't try to overtalk the judge. And then if you're referring to the judge, try to say your honor instead of, but judge, just say your honor, and most judges will appreciate that. But coming to court, I just encourage you guys to be prepared. If you have your judgments already prepared, that's very helpful. If you can have that done. Also, make sure that you circulate, because if you don't circulate the judgment, then that will cause your judgment to be delayed. So we always ask, you have your 9.5 certificate saying that you actually circulated. That's really important. If you think that you're going to have any exhibits that are going to be introduced, then make sure that you have your exhibits paid for already, if you can. If you prepare the judgment after the hearing, make sure that you do it. Most judges are saying that you need to have the judgments in within 10 days from that hearing. And then also make sure that if you're deciding that you want to take a writ from whatever the ruling is, just know that you shouldn't file, or you shouldn't present your writ until the judgment is actually filed. And some people think that it's 30 days from the actual hearing date. It's 30 days from actually signing. And so that's really, really important as well. So you kind of look at those things and see like where we are. And I know we have, I know I'm at 12:50. So do you want me to stop here and then take questions? Do we have any questions? Okay, so I'll tell you quickly then about pretrial. So every judge has a procedure for how they handle pretrial scheduling orders, settlement and pretrial conferences. And so I will make sure again, when you're requesting it, make sure that you request it timely. Also, when we look in and we get into abandonment issues, keep in mind that you have to have some proof or some information that you're trying to do, trying to prosecute the case. So just make sure that you are filing information and filing it timely and filing it correct, and then make sure that you are communicating with the judge again. The pretrial pleadings. Ensure that you are following the code requirements and then context. So what happened is that when people file motions for summary judgment, we will get a mover. And for whatever reason, people struggle with when the opposition is due. And so we get people who sometimes don't file opposition to the motion for summary judgment, and sometimes we're trying to figure out why. And so if you have a motion for summary judgment that's been filed and you really believe in your case, then you need to file an opposition. And it kind of tells the judge like where you are and why the other side is wrong. And so you can have cases dismissed as it relates to the summary judgment. So you guys may want to try to make sure that you're actually doing that. Judges and their staff have a lot to process, so don't just assume that your case is the most important case on the docket. Make sure that you follow up with the staff, make sure that you communicate with the staff, confirm your settings, make sure that you've done everything that you're supposed to do, and it just makes the job easier. I will tell you also, do not submit pleadings with a hanging judgment. So a hanging judgment is a judgment where all of the order language might be on page 1, and then on page 2 is just a signature line for the judge. A lot of judges won't sign that document, and so that's too easy to transfer, and we've had cases where people have actually transferred. So I will tell you, don't submit that. Another thing that we see in civil district court often is issues with insurance. And so I will tell you guys, if you are representing people, especially on the PI side, or if you have friends and family who are purchasing automobile insurance, you may want to have a conversation with them on how they're selecting their uninsured motorist component. And so I'm hoping that we'll have a CLE on that area soon, because there's a new selection on the form for insurance companies throughout the state of Louisiana that says economic only. And that economic only laws does not really render a person having uninsured motorists. And so I would just tell you that pay attention to that for your clients, and then for your friends and family as well. We've had a lot of people to believe that they had uninsured motorists. We have a lot of cases that are coming out of the fourth and fifth, and we're seeing it over and over again where we've had people, take the appeals. And I'm wondering, when it gets to the Supreme Court, how will the Supreme Court rule? We have rules that say that certain things are supposed to be selected on the insurance forms. And I think litigants don't realize what they selected until it's challenged in court. So just make sure that if you are advising people as it relates to insurance, you may want to address the issue with the uninsured motorist and then deal with like a economic only component. Attorney Smith, when you see people that are coming into court, as far as opposing counsel, what thing I guess annoys you the most when you receive a pleading?
I'll say for me, one thing is exactly what you're talking about. Like, you are out here essentially saying or putting in your pleading what we called in law school bad law. So you're saying that this case stands for that, and the case does not stand for that. So I'm exactly like Judge Sheppard, because when I get a motion for summary judgment, an exception, anything, the first thing I do is I pull everything that they're citing in their motion, and I make sure that that says what they say it says. And a lot of times it doesn't. So that's the number one thing. I would say the number two thing for me, which is a pet peeve, everybody knows, is proofreading. Please make sure you proofread, your pleadings, because as attorneys, you want to make sure that you're getting your point across to the judge. Judge Sheppard is getting these pleadings, and if she can't understand what you're saying, you're not getting your point across. And I think we all know by now that a majority of cases are won on paper before you even step foot into court. So just make sure, that the judges know exactly what you're trying to relate to them.
And that's so important. It is so true that really when we read those pleadings, generally, unless something that's said in oral argument is, presented and it wasn't presented in the paper. And sometimes if it was something that was moving, then I'll, take a break and kind of go research that particular issue and then come back. But generally, I provide reasons on the record for whatever the ruling is going to be for that particular case. So that would tell you that we've already had to read it and we already had to be prepared. So I would just tell you that oral arguments are great, but I would just tell you guys to have strong motions to help you in assisting your case. And then also, if you don't submit any pleadings in opposition, then some judges won't allow you to argue, and the code supports that. And so if a judge allows you to argue, then that's just a courtesy that the judge is extending to you. So that's really important as well, because we'll get people who will pose these arguments, and they'll say, okay, well, you know what, I submitted. And we're like, no, you didn't, because we don't see anything in our system. But Judge, I ran into this problem, so I kind of want to just, if I can just, and then I have another attorney on the side. But Judge, he didn't submit anything, so we don't even know what he's going to say, and if we had an opportunity to. So it kind of gets sticky. So just make sure that when people are filing these pleadings, that you are doing your part. Check the court's records. Don't have a lot of excuses. You can't be identified and known as the excuse judge, meaning every time you come to court, you have an excuse. I think life happens for everybody. I was in Baton Rouge this morning, as I told you guys in the beginning. I drove back here from New Orleans, and I'm going to start my rule docket at the conclusion of the call. So originally, rules were going to start at 10, but, life happened, so we had to modify it. So life happens for everybody. But you can't have an excuse all the time. You can't have an issue all the time. And you don't want to have that kind of reputation. And you also don't want to have a reputation of not having good arguments and that kind of stuff. And you don't want to have poor plea complaints, because it does matter. And so certain attorneys, there's an expectation, and we want your expectation to be a good expectation.
Right. And I'll just say one final thing in closing. If y'all don't take anything else from this call, take that procedure kills. What do I mean by that? If you know your procedure, you are really doing something. Because it's like Judge Sheppard talked about, if I file a motion for summary judgment, I know that you have to file your opposition within 15 days, not 8 days. A lot of people get that mixed up with the uniform rules of district court. So if you're filing your opposition in 8 days, that's untimely. Just knowing your procedure, being able to file these motions to strike or anything, exceptions, that would really get you a long way, because killing people on paper before you even get to court, that's a true art of war. And I'm sure Judge Sheppard will agree.
It definitely is. And that's why when you guys are filing your initial petition, attach the interrogatories. It kind of sets a different tone. It lets the attorney know on the other side that, you're prepared, you're ready, and you're ready to rumble if that's what you have to do. But just prepare and then write it. Like, don't believe that you're going to argue, because sometimes you can only argue for a couple of minutes, and you won't be able to get all of that information in. So make sure that you reduce it to writing and practice being a strong writer. Last thing I'll tell you guys, because I know we have to wrap up, is that if you are new to the practice or if you've been practicing for a while, call around to the different courts and see who's having rule days and see if you can kind of, either participate if it's by Zoom, just as an observer, or just come and physically sit in the courtroom. If you run into a situation where you run into pleadings that you need and you have no idea how to prepare those pleadings and you don't have anybody to call, I would encourage you guys to research on Westlaw or LexisNexis. If you don't have access to it through your bar membership, you have access to Fastcase, which will allow you to research cases. So look up those cases, research it, and then go to the district court in your area where that case was filed and go through that file. And if you need to make a copy of the pleading to give you a guide on how you're supposed to draft the pleading, then do that. But you do the research to have a well-pled complaint submitted, and don't make it up as you go. So thank you. Attorney Smith, any final thoughts?
No, I think that's it. I just thank Ms. Dickerson for inviting me here today. I'm grateful again to be on the panel with Judge Sheppard. Great information. I hope y'all were taking notes, and just let us know if y'all have any questions about anything, because it's our goal to make sure that y'all succeed.
Okay, thank you so much. Director Dickerson, thank you again for having us on. I enjoyed being on the panel and the presentation submitted by Attorney Smith. And thank you again for the hard work that you're doing. And of course, thank our Chancellor for the hard work that he's doing to make sure that our SULC grads are adequately educated. So thank you all again. And thank you to everyone who logged in to participate with us on this afternoon. Thank you.
Thank you all so much for tuning in, and I know you got a wealth of information from our two panelists. Stay tuned next week for our third installment of Becoming Fierce in the Practice of Law. It's the Legal Research Edition, and I will see you all soon. Have a good weekend.
Thank you. Bye, y'all.